Hey, Michael, my name is John. I'm gonna take down what you say, so I need your sworn testimony. Raise your right hand for me, please. Swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I don't think God has any interest in this matter, but I do swear to tell the truth.
Very good. Don't forget, keep that voice up, okay? I'm a little hard of hearing.
Okay.
Thank
John,
you.
what's your last name?
Drury.
You're a stenographer or?
Yeah, I'm an independent.
Okay.
That's it, yeah.
Good morning, Mr. Franklin. As I said off the record just a few moments ago, my name is Danielle Smith. I'm an attorney for the city of Syracuse, and you are here to give testimony on the notice of claim that you filed. I understand that you are recording this on your own personal device, again, as we discussed off the record. I have no objection to that, provided that the recording is just of this room, because the rest of this space is used as a law office and there are confidential and privileged materials that can't be recorded. And you have agreed to just record this proceeding in this small office. Is that a fair representation?
Sure, and just remind me to turn everything off before I leave this room.
Will do. I would also ask that you keep a copy of that recording if this does proceed to a lawsuit. If you do decide to commence a lawsuit, I will be requesting a copy of that recording during discovery. Is that understood?
Sure.
Thank you. Have you ever been deposed before?
No.
Have you ever given testimony under oath before?
Yes.
We have a court reporter here that is taking down everything that you say and everything that I say. The court reporter cannot take down shakes of the head, hand gestures, only what is actually orally said. Do you understand that?
Yes.
It is very natural that we shake our head, that we use our hands when describing something. There may come times when you do that and I might ask you to describe what it is you're doing. Do you understand that?
Yes.
If you are at any time unable to understand my questions, please let me know. I will be happy to rephrase. However, if you do answer my question, I will understand, I will believe that you understood the question. Is that fair?
Yes.
I don't expect this to take a particularly long time. However, if at any point you need a break to use the restroom, to grab some water, that is perfectly acceptable. Just please answer my question before taking the break, okay?
Okay.
At present, are you taking any medications or drugs of any kind that might make it difficult for you to understand and answer my questions today? No. And just as another pointer, there may be many times when you think you know how I'm going to ask a question. I would just ask that you let me ask it fully before you answer, so we're not talking over each other. It makes it much easier for the court reporter, okay?
Okay.
Thank you. Is there any reason today that you would not be able to accurately remember events and answer questions truthfully?
No.
What is your full name?
Michael R. Franklin.
Have you ever gone by any other names?
No.
How old are you?
62.
And where do you currently live?
12 Point View Drive, Central Square, New York, 13036.
Give me that address again.
12 Point View Drive,
Point View, go ahead.
Central Square, New York, 13036.
Okay.
My office, my real estate office, is at 1406 North State Street, Syracuse, New York, 13208.
And just so the record is clear, the 1406 North State Street address is the address you listed on your notice of claim.
That's correct.
What is the highest level of education you have completed?
Associate's degree,
In what?
accounting,
And when was that?
1983.
Are you currently working?
Self-employed.
And what are you self-employed as?
I'm a New York State licensed New York State real estate broker, and I run the propertytaxguy.com. I advocate for property owners in assessment matters.
And just briefly, what does that entail when you say advocating for property owners?
I represent them in board of assessment review hearings and small claims assessment review hearings.
And do you do that in the city of Syracuse?
I do it all over the state, including the city of Syracuse.
And what other municipalities do you travel to in your work?
To date, approximately 37 counties. It's probably participated in over 400 cases.
And is that all within New York State?
Yes, it's New York State law.
And the work that you just described, is that the work you were doing in February, March, and April of this year?
That is correct.
And who pays you for your work?
The taxpayer.
And what is a typical fee for your work?
It depends on the circumstances.
Can you give me any examples?
Can I give an example? Well, the case at hand was pro bono.
Is that typical?
Is it typical? I try to maintain a balance of pro bono cases, as a public service. So I do a lot of pro bono cases. I help a lot of people for free on the phone and give them advice on how to do it themselves. Some I represent for free, and many I provide proposals to. It depends on the nature of the property, the value of the property, the municipality that it's in, because tax rates can vary very significantly across the state. So I provide custom proposals.
And how long have you been self-employed in this real estate business?
Real estate, I believe I started in 2001 or 2002. I became my own broker in 2013. I think I got my license about 2005.
And what license is that?
Well, initially it was just a real estate salesperson's license, and then I have a New York State broker's license.
What
As
would be-
of 2013.
And what's the difference between the license you received in 2005 and the broker's license you received in 2013?
Well, when an agent lists a property, the contract is not between the property owner and the agent, it's between the property owner and the broker. So the broker can take on agents to work underneath them. So the agents are agents of the broker, and but the broker is of record for the transaction. So I'm a sole proprietor broker. I have no agents working for me. It's simply as me, but I qualify as my own broker.
Have you ever had agents work for you?
Never.
Yeah.
Didn't mark that.
Oh, not a problem.
Did you say A or what?
A1, whatever. You want to mark it
I
as.
go A. Exhibit A marked.
Thank you. Mr. Franklin, I am handing you what has been marked as Exhibit A. If you could just take a moment and look through that, take all the time you need.
read all these just before I got here, so I'm familiar with them.
Okay. And I realize that might be printed in black and white. The version you might provided to us might be a color. So with the exception of any color differences, do you recognize that document?
I'm pretty certain that they're identical.
Okay. Is that the notice of claim that you served on the city of Syracuse?
Yeah, it's looking, I wanted to verify, to be sure, but let me just, make sure.
If you take all the time you want, if you want to compare page by page, you're more than welcome to do that.
Yeah, I think so. Oops. Yep, that is it.
That is the notice of claim?
Yeah, correct.
Great. And just to be clear on page 1, there's a signature on page 3. Is that your signature?
It is,
And the signature on page 4, is that also your signature?
it is.
Okay, turning to the first page. In the third full paragraph, it reads, "The said acts above referred came in the form of a Board of Assessment review decision rendered in 2 letters dated April 1st, 2024, and placed in the public record." Do you see that?
Yes.
If you turn to page 5, I see a letter regarding 209 Parish Lane. Do you see that?
Yes.
Is there a second letter?
Yeah, there was a different property, this is 209 Parish, and the other property was, something Maryland Avenue. And he sent basically the identical, addendum on that one. Basically, he used this as boilerplate and sent them both. It probably only changed the address.
Okay.
So there is another letter, it's basically identical to this one regarding, I think it's 949 Maryland Avenue.
Spell that street.
Maryland, Maryland.
But just so the record is clear, that not what we'll call the 949 Maryland letter, that letter is not included in your notice of claim.
That's right, and just to clarify, there was 2 properties. He disparaged me on both determinations. On this case, I won the appeal. On the other case, I did not win the appeal. Okay, so this is the stronger because they're saying that I'm all these things when I won the case, so how can I be all these things? So I can provide a copy of the other letter. You guys should have it on file. It's part of the public record.
Okay. I just want to make sure that I understand what it is you're basing your notice of claim on. Are you basing it on both letters?
I'm basing on both letters. I don't think it makes any difference. I think one is adequate. I'd have to think about that. I mean, he disparaged me twice in public. Well, so yes, it does matter because I want both addendums removed from the public record.
Okay.
So it does matter, and I can provide the other copy. So even though the other case I did not win on appeal, he still disparaged me.
Okay. If after this proceeding today you do locate this other letter, if you could email that to the office or mail it in or
Sure.
drop it off, however is easiest for you, I would appreciate it so that I just have a complete record of what it is you're basing your claim off of.
I'll send you a copy of that, and I will send you a copy of the video as well.
Thank you, I appreciate it.
Probably tomorrow.
That would be great. Okay. And again, if you could just read through the first 3 pages of the notice of claim, which I think is a factual summary of your claim. You refer to disparaging remarks and letters, etc. Again, is that the 209 parish letter that we're talking about and the Maryland letter?
Yes.
Okay.
Yeah, and quite frankly, I have another one here for you that's, this was written by Trevor McDaniel, and he disparaged me as well, but he didn't sign it, so I didn't know if it was relevant, because he smartly didn't sign it. He says I'm unqualified, and frankly, I don't know who's more qualified than me to handle these matters in New York State.
Are you?
I can leave you a copy of that, and I'll just take a picture of it.
It appears that there is a final page that might be missing from that document.
No, that's all that they. This is what he provided to the to me in the SCAR hearing, and so this says conclusion. I think he purposely did not sign it. He was in a big hurry. He held up the hearing for about 15 minutes while he went back and got all this together. But not only did he disparage me, but he doesn't seem to know that SCAR cases are de novo, because it would have saved him 2 pages of typing had he known that. And also, the cases are de novo, and he was talking about the wrong property. He's writing all this stuff about the wrong property. He was just hilarious. But he needs to know SCAR cases are de novo.
SCAR cases are what?
De novo, as if new. So he disparaged me, and he disparaged me in the hearing, in the SCAR hearing, but they don't allow SCAR hearings to be recorded. And so I don't have evidence of that other than this right here. And he also accused me in a public hearing, a public bar hearing, of I think criminal eavesdropping. It's unbelievable. But anyway.
Okay. If we could go back to the notice of claim that you filed. Okay. So on page 2, the second paragraph, you have a quote in here. The Board of Assessment Review has determined that Mr. Franklin is not sufficiently knowledgeable to speak regarding the property and therefore cannot currently qualify as a viable agent for the property owner as it pertains to the actual value of the property. And that is a quote from the 209 parish letter, is that correct?
That's right. I'd have to verify that it's word for word, but I intended for it to be word for word.
Understood. So if you could turn to the where the letter is in the notice of claim, I think it's on page 5. And I believe that quote is the first half of the 3rd paragraph.
I think that's identical, isn't
It appears to be yes. Again, I just want to make sure that we're all talking about the same
Sure.
thing. And is it your position that that is an untrue statement?
Like I said, I don't know who would be more qualified than me in New York State, in upstate New York, rather.
And do you believe that you were knowledgeable to speak about the property?
Yes, I am.
And again, we're referring to the 209 parish property, correct?
That's right.
So that paragraph continues on, it looks like the second sentence. The board finds it difficult for an agent to accurately represent the state or value of the property when the agent has no knowledge of the inventory, renovations that have been performed with or without a permit, or the details regarding the sale and purchase of the property. Do you see that line?
Yeah, where are you?
I'm still on that same paragraph, it looks like the third paragraph, it's just the second half of that.
Okay.
You had quoted the first sentence, I just read the second sentence.
Okay, what was the question?
Did I read that correctly?
Yeah, I think so.
Okay. What does the word inventory mean to you in this context?
Inventory, it's, number of bedrooms, number of bathrooms, square footage, things of that nature.
Were you familiar with the inventory of the property at the time of this hearing, which appears to be February 14th of 2024?
Yes, and certainly more so than the assessor.
Okay. Were you familiar with renovations that had performed with or without a permit at the property?
With or without the permit? With or without the permit of the property. To my knowledge, there were none,
Okay.
but, you know, that was a while ago, so I'd have to review the file.
And what about details regarding the sale and purchase of the property? Were you also familiar with details regarding the sale and purchase of the property?
Yeah, I'm familiar with all aspects of the property.
Okay.
I've reviewed the property in the same fashion that the assessor does.
Okay. Did you visit the property?
Yes,
Did you go inside the property?
I never go inside the properties because the assessor cannot go inside the property. So I want to value the property in the same manner that the assessor does from the street. I don't want to invade people's privacy or create security issues. Because if I submit interior photos of that property at a bar or SCAR hearing, they become public record and anybody can foil them. And I don't think it's appropriate. It certainly isn't appropriate for the assessor to go into somebody's house. And I don't think that they should even ask. And so it's my policy, I'm not saying that I've never gone into somebody's property, but since it became an issue, it's my policy moving forward not to. You know, maybe they ask me to come in for a drink or something, maybe I would do that. But it's, I go out of my way not to go into people's properties specifically because that's not what this is about. I value the property in the same manner that the assessor does.
And I want to make sure that I heard you correctly. Is it your position that the assessor should go into the property? Or should not, I guess?
He should not, and not only that, they should not even ask. Because this is America, not Russia.
Okay.
And I will say that the invading people's privacy for government's cost accounting purposes is inappropriate.
Is the same also true of the 949 Maryland Avenue? You did not go into that property, actually.
I go into the property and I viewed it in the same manner that the assessor could. I did not go inside the property.
So how is it that you, walk me through your process of assessing a property if you do not go inside it?
If I don't go inside it, well, I analyze it through public information. And I typically will do a drive-by. I look at satellite imagery. I analyze the comparables. The first thing I do when a client retains me is I foil their comparable sales report, their comparable assessment report, their cost evaluation report, their subject property inventory summary, their land tables, their cost tables. It depends on the property. I have a checklist of what it is that I look for. And basically, I analyze the assessor's data. Because when you're in a bar hearing or a SCAR hearing, you know, they only pay SCAR hearing officers $75 for a case. So I don't want to confuse it with all kinds of comps. So I want to talk about the same set of data. The comparable, I want to use the assessor's comparables. I analyze their comparables. I analyze their costs. I look at the inventory items. I make certain that they're either correct or they're incorrect. And then I see if the assessor violated the law. In this case, the assessor violated the law. He violated welcome stranger, as was indicated in the SCAR decision, and he does it routinely, and it's inappropriate. And the reason he does it is because he knows he can get away with it because there's no legal ramifications to him violating the law. And so your Board of Assessment Review doesn't seem to understand the law.
Can you explain what you mean by welcome stranger?
It's selective assessment when they pin the purchase price. So if a municipality is not at 100% equalization, like the city of Syracuse hasn't been in 25 years, they haven't done a revale in 25 years for political purposes, because politicians avoid revales like the plague, because they will get voted out of office because it riles up the taxpayers. So if they're not at 100%, if they see a sale, they can't pin that sale unless they bring all the other properties up to that point. And that particular assessor does that routinely. He did it the year before for the property across the street from this property, and I won that case. And then he did it again right across the street, and I won that case, even though they say I don't know what I'm doing.
If you could turn back to page 2 of your notice of claim. The 4th paragraph down, it starts off the RP-524.
Mm-hmm.
What is an RP-524?
That's a Board of Assessment Review petition.
And the paragraph continues on, the RP-524 designated Michael R. Franklin as the legal representative of the taxpayer.
Right, just to clarify, NRP 524 is a state form, so this is state law. And per the state law and the state form, I am the legal representative of that taxpayer, as authorized by that taxpayer.
Okay. Some time ago I asked you your education, you mentioned an associate's degree. I just want to be clear that you are not an attorney.
I'm not an attorney. I was a small claims assessment review hearing officer for 4 years in 6 counties.
In what county?
In which counties?
Yeah.
You just asked me what was the word that you used.
Oh, counties, in 6 counties.
On occasion, our court reporter might ask you to repeat a word if he doesn't if he did not hear it.
Yes.
So what is it that you mean when you say legal representative then?
Well, when in Board of Assessment Review and Small Claims Assessment Review, they're quasi-judicial processes, and you don't need to be an attorney to represent people, because frankly, when it comes to valuation, I think it'd be more appropriate to have somebody who knows something about valuation than somebody who's more versed in the technicalities of procedures, law, because SCAR hearings are informal.
Something very odd. If we could just go off the record for a second.
It's still recording. Feedback. Let's see.
6, 7. Mind if it's all.
Yeah, let's do this. Okay. God damn it. All right, there we go. Sorry about that. Okay.
Go back on the record.
Yeah.
So I believe we were talking about legal representative.
Mhm.
Have you ever held yourself out as an attorney?
No. I put specifically in the first line of my agreements that I'm not an attorney, and I believe I put it in the last line that I'm not an attorney.
So the following paragraph says, Joseph Saya, S-A-Y-A, disparaged the claimant to his clients, tortiously interfered with claimant's financial relationship with taxpayer clients, but also did so in a public document. Do you see that line?
Which page?
Second page, fifth paragraph down.
Yes.
And did I read that accurately?
Yes.
And again, you're referring to the 209 parish letter when you say that Joseph Saya disparaged the claimant?
He did so in both the Maryland case and in the parish claim case.
Okay. So those two letters, the Maryland letter and the parish letter.
Correct.
And how did he tortiously interfere with your financial relationship with your clients?
Well, when my clients get that decision in the mail, and it says that, what they said about me, from an authority figure such as the city of Syracuse, it caused them great concern.
I believe you said that the 209 parish was a pro bono case, correct?
It was.
What about the Maryland one?
It was not a pro bono case.
And what was your fee for that?
Where there was no fee for it because I lost. It's contingency based.
Understood, okay. Do you typically get a percentage of whatever you might win? Is that how your fee arrangements typically work?
Typically, yeah.
So, just so I understand this, had the parish case not been pro bono, you would have received a fee for that case
That's right.
because you won,
That's right.
but not for the Maryland, even though if you had won Maryland, you would have received a fee,
That's right.
but you lost Maryland, so you did not receive a fee.
That's correct.
And again, so the record is clear, when I say Maryland, I'm referring to that proceeding, the parish, I'm referring to the 209 parish proceeding.
That's right.
Does that make sense?
Yes.
Okay. I think you said that your clients were, and I'm going to paraphrase, feel free to correct me, essentially concerned, right, when they received a letter from the city of Syracuse. Did that impact you financially in any way?
Well, it certainly could, because I could handle the case next year. See, the any potential damages, I didn't ask for any in my notice of claim, but the damage that this has and the continued placement of these in the public record, it's a seasonal business, and I probably won't find out until next year, until this coming year. But I didn't ask for those kinds of damages in my claim.
The letter, if you turn to page 5, which is the 209 parish letter, it appears to be sent to your 1406 North State Street address. Is that correct?
That's right.
Okay. Was there also a letter that was sent directly to the clients?
I emailed it to them.
Okay, so you received this letter from the city of Syracuse and you passed it on to your clients?
Right, they're supposed to send the decisions to me because I'm the legal representative, and then I pass it on to my client.
Okay. And is that the same for the Maryland letter as well?
I'm sure it is, yeah.
Do you know if anyone else saw this letter beyond your clients?
Beyond my clients?
Yes.
I have no idea who's seen the public record at this point in time.
Has anyone else come up to you asking about these letters?
Asking about these letters? Not that I recall.
Okay. So to your knowledge, you've seen the letter, you've seen the 209 parish letter, the Maryland letter, and your clients have seen those letters as well, correct?
Correct.
To your knowledge, has anyone else seen those letters?
I have no way of knowing.
Okay. But nobody has brought them to your attention?
Not that I can recall, no.
And I apologize for the jumping around. If you could turn back to page 2. That same paragraph that starts Joseph Saya, you end it with, but also did so in a public document.
Mm-hmm.
And again, the public documents you're referring to are the letters that we've been talking about, is that correct?
That's right, the bar decision with its addendum is public record.
I'm sorry, can you I'm not sure what you mean by that.
The Board of Assessment Review decision, which is a state form, I think it's called an RP 525. And his letter is an addendum to the RP 525.
Understood, thank you. And when you say that these are public documents, what do you mean by that?
That they're foilable.
Okay, so anyone off the street could request these
That's right.
documents? And have you done that?
Have I requested those documents?
Yes.
I already have copies of them.
But
No would be the answer, sorry.
That's okay.
Sorry.
And again, on page 2, the next paragraph down, claimant alleges the city of Syracuse is vicariously liable for Joseph's, is vicariously.
You said second paragraph?
I'm sorry, 6th paragraph, 2nd page, 6th paragraph.
Mhm.
Claimant alleges the city of Syracuse is vicariously liable for Joseph Saya's actions. Did I read that correctly?
Yes.
And what do you mean by that?
Well, he's a representative of the city of Syracuse. He's employed by the city of Syracuse, probably as a contractor, but he's the chairman of the Board of Assessment Review, which was appointed by the common council.
If you could actually turn to the very first page, your notice of claim is against Ben Walsh as mayor for the city of Syracuse and also Joseph Saya as chairman of the Board of Assessment Review for the city of Syracuse and the county of Onondaga, New York. Is that correct?
Yes.
And we've talked about Joseph Saya. Is there something specifically that you're alleging against Mayor Ben Walsh?
Well, the buck stops with him.
So as the mayor,
You know,
You're-
I would expect the mayor to order these people to meet my demands.
okay. Has the mayor personally disparaged you in some way?
No, but he did lie in a foil denial. You might call it you might not call it directly a lie, maybe it's a white lie, maybe it's disingenuous, but he lied in a foil denial. He said that the comparable sales report didn't exist. Well, it's in the computer. You just run the report, so it's kind of disingenuous. And so, is it specific to this case? No.
Okay.
But the buck stops with him, and he could tell these people, don't be disparaging people in these decisions, and honor the FOIL requests in a timely manner. Don't force people to sue the city over petty nonsense. Instead of having a year-long lawsuit over a report that takes 5 minutes to run, they just wasted the taxpayers' money in a mind-boggling way. All I'm asking them to do is to honor their FOIL requests and hear my case. If you disagree with me, then you don't give me a reduction. It's as simple as that. But they normally, when they do a 525, they just check the box that says insufficient information. But for me, they write War and Peace, disparaging me, and it's inappropriate, and it shouldn't happen.
If you could turn to the next page, page 2.
We'll go with audio from here.
Okay. The second to last paragraph, which also is the 7th paragraph on the page. Claimant has suffered substantial reputational damage and costs associated with clearing the disrepute in public documents. Do you see that line?
Yeah, I do.
Okay, and did I read that correctly?
I think you did.
And what reputational damage have you suffered?
Well, it's the ongoing inclusion of the disparaging remarks in the public record.
So essentially, the knowledge that those letters are out there, is that what you're referring to?
That's right, he's got no business saying those things about me. And it from a position of authority with the city of Syracuse. So, like I said, I have not asked for any money damages in this thing for myself. It's basically I'm asking for injunctions, and I want that removed. I don't think it should be a big deal. Just remove it. And I would like a letter from him apologizing, so that I can show my clients that.
The 209 parish clients, have they indicated they would not retain you the following year because of this letter?
Well, they won, but the Maryland Ave one did not. But again, I'm not asking for financial remuneration, but it it certainly perked their ears up when they're reading this stuff.
Sure.
And it's hard to know what these people think of that.
I apologize, I don't need to keep re-asking some of the same questions, I just want to make sure I understand. So the 209 parish doesn't need to retain you in the future because they won, is that correct?
No, they could, the assessor could go after them again next year.
Okay, if that happens, did the 209 parish people indicate that they would not want to hire you again because of this letter?
Oh, they haven't indicated anything.
Okay.
So, I don't know, but, like I said, I'm not going after money damages, but, it's hard for me to know what's in their mind after reading something like that. It would be kind of like, you going into court and the court disparages you in a public document. I don't think you would like it.
And what about the Maryland property? Have you had any conversations with them about future employment?
No, maybe I tell them when May 1st comes along, the tentative roll comes out, take a look at it. If there's an issue, give me a call. I'm sorry, not May 1st. It's usually May 1st. In the city of Syracuse, it's January 1st.
Has anyone else suggested they would not be retaining you because of these letters?
No.
And the second part of that sentence refers to costs associated with clearing the disrepute in public documents. What costs have you expended?
I don't have any expenses thus far, but if it has to go to court, I'll have filing fees and things of that nature, service fees, things like that.
Okay. And then the following paragraph refers to, I think, FOIL issues. It says, in addition, the city of Syracuse selectively refused to provide assessment data to Michael Franklin because he is Michael Franklin. The assessor's office refused Michael Franklin data that they routinely provide to other taxpayers on demand at the assessor's counter in violation of NYS FOIL, New York State FOIL. Did I read that correctly?
Yes.
When have you gone to the City of Syracuse Assessment Office to seek materials?
When was it? Well, it was the day of the SCAR hearing, which was
Day of the what?
Small Claims Assessment Review hearing. SCAR. Late May, I think it was.
The 209 parish letter says that it was February 14th. Could that be correct?
No.
No.
I don't think I went there in person in February. I don't think. But the day of the SCAR hearing, before the hearing, I stopped in to see them because they hadn't fulfilled my FOIL completely. So I went down to ask for the part that they didn't do, so we could avoid another lawsuit. And Tom Johnson threatened to call the police on me.
And who is Tom Johnson?
He's a deputy assessor.
And I'm assuming they refused to provide you the material, is that correct?
That's right, and so my point in this case is that if they provide any of these reports to anyone, they need to also, they cannot single me out. If they provide it to anyone, they must provide it to me. Now, if they're busy, that's okay, but they can't just say, oh, it's Mike Franklin, we're busy, because that's what they're doing.
And did somebody say that to you, we're not providing these materials to you simply because you are Mike Franklin?
No, but they asked for my name. In FOIL, you can FOIL anonymously. There's no need to know my name. And so as soon as they heard my name, they called Mr. Black on the phone. He says, make him FOIL it, he says.
Okay.
So it's inappropriate. Just give me the reports. It's public information. The taxpayers paid for it.
Okay, so that was the response, was that you should FOIL the material.
That's right, and Tom Johnson threatened to call the police.
Okay. And did he tell you why he threatened to call the police?
I have no idea. He's just, these people are so triggered. It's like, just give me the data so we can have an apples and apples conversation at Bar and Scar. It's as simple as that. It's some sort of an ego thing, some sort of territorial thing. You're not going to get my. In fact, your deputy assessor told me at a bar hearing, you will never get my data. And then at the after the Scar hearing, where I mopped the floor with he and two of your lawyers, he says, well, I got the data from the hearing officer, and I showed it to him at the hallway. He threatened to beat me up in the hallway.
And who was that?
In full. Threatened to beat me up in the hallway, and then I foiled your hall cameras so I can get a look at what happened. And your hall cameras weren't particularly useful, but he said you will never get my data, and I think the issue is that he doesn't understand. It's not his data; it belongs to the public, and all this would go away if they would just respond to my FOIL responses completely, write a certification as they're required to by law, and just give me the data in a timely manner. Don't drag it out to the very last day that's legally possible, and play all their little FOIL games. Just give me the data, and it doesn't have to be contentious. Actually, all of this happened because of FOIL, because they won't give me the FOIL data. That's what this is all about.
Other than that date, I think you believe it was sometime in May, and it's fine if it's not. Have there been other times that you've gone to the assessor's office looking for material?
I went there today.
Okay. And what was the response?
Joe Acaro, I think is his last name. He's a deputy assessor. He said he's never heard of a cost valuation report. He's an assessor. He doesn't know what a cost valuation report. It's ridiculous. And actually, your assessor, your head assessor, who apparently is an attorney, said he'd never heard of a cost report. Disingenuously in the lawsuit, it's a cost valuation report. I'm sorry, I forgot to put valuation. Cost valuation report. He disingenuously said they don't have a cost report when he knows darn well that they do. And so Joe says, I asked Joe, Joe, do you give any of these reports to any other people at the counter? And Joe says, not to my knowledge. But Joe has no problem lying under oath because he did so at the bar hearing. And I can prove it. He lied under oath, and so he has absolutely no problem lying right to my face. It was, I don't know any assessor's office that won't give you those reports if you walk in and ask for it. You walk in the man nest, you ask for the reports, they give you the reports.
Okay, so there's been 2 times that you've requested the material from the assessor's office. One time you were told to FOIL the material. The other time, it sounds like they simply did not know what document you were talking about.
Well, they just say they don't provide those reports at the counter,
Okay.
which I'd like to see him say that under oath because I know it's not true.
Okay. And I think that gets us to the second sentence.
Page 1?
2 into 3, page 2 into 3. That's the very last sentence on page 2. The assessor's office refused Michael Franklin data that they routinely provide to other taxpayers on demand at the assessor's counter in violation of New York State FOIL. Do you see that?
I do.
Okay. And what is the basis for that statement?
Well, the basis is that you can't treat people unequally. And if you're providing it to the other people, you must provide it to me. You can't, just because you hate my guts, it doesn't mean you withhold the data. And they clearly hate my guts. So that's why they're withholding it.
And who do you know that has been able to obtain that material from the assessor's office?
I can't name anybody specifically, but people just do it. So I worry about what I get, but I know for a fact that people go to these counters and get it. I can't name anybody. People just go.
If you can't name anybody, how do you know for a fact that is occurring?
Well, common sense.
Okay.
Common sense would dictate. So, but if we have to get into it, I'll prove it. So, if it becomes necessary.
Has anyone, I guess, told you that they were able to get that material from the assessor's office? Have you seen anyone get that material from the assessor's office, even if you can't recall any names?
I just can't remember specifically. But again, I have no problem. When the time comes, I'll be able to prove it to you.
And how would you prove it?
I don't think I want to give you my methodology because I'm going to have to do it without it being me.
Okay, so essentially...
Because they won't give it to me, As soon as I walk in, they just climb right up.
Okay, and then I think that final paragraph on page 3, I believe is what you're asking for. Is that correct? Please take a moment and read that paragraph.
Page 3?
Yes.
Yeah, first sentence would be if it had to go to court, obviously. Provide assessment reports at their counter on demand, no matter who requests them. And again, if they're busy, I can see how they're tied up or whatever. We can't do it right now, but they can't just do it because it's Mike Franklin. It's public information. If they're available to run the reports, they should run the reports.
If they're available, what?
If they're available to run the reports, they should run the reports. If they're busy, they're busy.
What do you mean by run the reports?
All they have to do is go into the New York State Real Property System. There's a program that every assessor in all of upstate New York, probably the entire state, I don't know what they do in New York City, but it's called the Real Property System. And it's just a computer program, and all they have to do is go pull down the menu, hit cost valuation report. You can either print it to the printer or print it to a PDF and email it to somebody. That's all they have to do. It only takes a few minutes to do, but they don't want to give me the data. And the reason they don't want to give me the data is because they know that I'll be able to demonstrate that their valuation method is arbitrary and capricious, and that the city of Syracuse is not doing the job properly. They're paid to do the job, and they're not doing it. They haven't done a rebound in 25 years, and when you get paid to do a job and you don't do it, it's called fraud. The taxpayers paid for this job to be done. They have no problem taking money from all the taxpayers, but they have a problem doing the job of assessment and doing it in good faith. And they don't want to provide me with the data because they know that I'm going to make them look foolish. That's what I do. Is I make assessors look foolish in scar hearings. And full. I made a complete fool out of him in that scar hearing because he probably spent 2 minutes doing the valuation, and then he claims he's 100% right all the time. He's always right. He's never wrong. And then I just have to prove that he's not doing the job properly. It's what lazy assessors do. So basically, his whole function is to minimize the amount of work that he does and still get paid. And it's not just the city of Syracuse. It happens all over the state. And sometimes they pay favors, sometimes there's kickbacks, there's all kinds of things that go on. And the thing is, if you don't have the data, you can't figure it out. But if you do have the data, you can figure it out. They don't want you to have the data. And there's cases of that going on in Rochester where they scammed Kodak to the tunes of millions of dollars. The assessor would raise the assessment, his buddy at Kodak would hire this appraiser that they're both buddies with, and then the assessor would drop it, and then they split the proceeds. They're the tunes of millions of dollars. 2 of them died in jail. But they finally caught them. And the same thing happened in New York City. There's a 35-year kickback scheme going on the biggest properties in Manhattan. And if I have the data, I can figure out what's going on, but they don't want me to have the data. Request the assessor's office provide assessment reports. If counter on demand. Like I said, if they're busy, they're busy. So on demand it might be too strong. But you don't single people out just because of who they are and you don't like them.
Other than what's in this paragraph, is there anything else that you're requesting?
No, I don't want any money. I just want the reports expunged from the public record. I want to be able to get my FOIL data when I ask for it. And I want an apology just so I can show my clients that I do know what I'm doing. You're just not gonna make a public document and say Mike Franklin doesn't know what he's doing. It's not gonna happen. So it's a very simple thing. It seems the city of Syracuse likes to get into lawsuits for no reason. All they had to do last year was just run a report and give it to me. But instead they want to battle for a year. And so here we go. Do you want to battle for another year or two on this? Or do you just want to expunge the reports and have Saya write me an apology and just tell them these guys are going to give Franklin his FOIL requests and we're going to have civilized hearings moving forward and everything will be good. Just keep it nice and professional. And that's all I'm asking for. I'm not asking for money.
So I don't really have any other questions, but I always like to give the claimants an opportunity if there's something that you feel that I didn't ask or anything that you think I should know, any additional information that you want to share. I certainly want to give you that opportunity to say it.
Yeah. Well, the last thing I want to do is cost taxpayers money. I'm an advocate for taxpayers. And the city of Syracuse having to spend money on legal fees for this kind of stuff is not something I want them to have to do. But I think your board of assessment review needs to be flushed because 4 out of 5 of them know nothing about valuation. And Saya, I don't know if he knows anything about it either, to tell you the truth. They've got some notion. They've got Marty Masterpool is on there. He's a real estate agent. What do real estate agents know about real estate valuation? They know nothing about real estate valuation. He's there because his brother was the city auditor. It's cronyism. And Saya wants everybody to say the truth, so help him God, because he's Catholic. And my clients aren't necessarily white. And the city of Syracuse is more than 50% non-white. And they're all white across here, and they're all Catholic. And my clients don't feel like they can get a fair hearing. So they have to hire a white guy to defend them. And that's a true story. And it just isn't appropriate. Masterpool's got no business being on there. Chuck Fahey had no valuation experience. Nice guy, but he doesn't know anything about valuation. You got a paralegal on there, really good experience being paralegal, but it's got nothing to do with valuation. You got somebody from the Home Depot on there. I guess she did contracts of some sort. I don't know what that has to do with valuation. Get somebody on there that knows something about valuation. It's a crony-filled operation, and particularly how they handle commercial assessments. It's just they're forcing everything into court and wasting taxpayers' money. And trust me, your assessors are not always right. They are not always right. And I just want my FOIL data when I request it. And if I can get my FOIL data, we can have nice professional bar hearings, and they can deny me every time. I don't care. I'll take them to SCAR and I'll beat them at SCAR. But don't disparage me in a public document.
Okay.
Mm-hmm.
If you could, I think you agreed to send the Maryland letter. If you could email that to the law office, I would appreciate that.
Mm-hmm.
And again, if I could just ask you to turn off the recording, because I have no further questions.